Yes, good afternoon to everybody. Welcome to the today class,
Afternoon, sir.
PGLCT.
Good
Yes,
afternoon, sir.
welcome. And I could see the people are joining one after another. And today that we are going to deal the labor law, multiple choice questions, and it is the pandemic, especially those who are the aged, or the sexagenarian, or the senior citizen. They have to take the balanced diet. In Telugu, we will say the pushtikaramaina aharamu, and which is said to be a eggs, daily egg, one egg that you can take it, either the broiler egg or the country egg, but any egg you have to take it, either raw or the boiled one, or the roasted one, or the omelette one, preferably the boiler. The boiled one is more beautiful and good for health. I don't know whether how many types of the egg. I mean, which egg that you ate till now, sir? What is that? Which egg, sir? Sir, which bird's egg? My point is anyone. Yes, anyone mute and unmute and give the answer to my question. And which bird's eggs that you ate till now? ఏం సార్ అదేంటి సార్ కోడి గుడ్లు తిన్నాం సార్. ఓకే, కోడిగుడ్లు దాంట్లో లెగర్లు ఉంటాయి, కోడిగుడ్లు ఫామ్ ఉంటాయి, కోడిగుడ్లు అండ్ కంట్రీ ఉంటాయి, కోడిగుడ్లు. ఏది తిన్నారండి? అన్ని తిన్నాం సార్. బాతుగుడ్లు తిన్నాం సార్. ఇంకా ఇంకా అంతేనా? ఇంకేమైనా తిన్నారా గుడ్లు? ఎస్. బాత్ in the rough that I would like to share. See, when I was reading that, I found this thing, so I thought that I would like to share with you. The eggs are chicken eggs, but preferably we should not say chicken eggs. We can say hen eggs. That is a country hen. Country hen is one is white if it is a farm country, and if it is no, sorry, farm egg is white and country egg is like almond color. That is a country egg. Then duck egg. Sir, we know, sir, duck egg is bigger than the henry egg. And again, then turkey egg. Turkey egg తిన్నారా అండి సార్? అసలు మేము టర్కీ చూడలేదు సార్. టర్కీ ఎగ్ తింటాం సార్. టర్కీ కోడి చూసినాం సార్, అప్పుడప్పుడు ఎక్కడనో చూసినా సార్. అక్కడ టర్కీ కోడి జువాలజికల్ పార్క్ లో చూసిన సార్ టర్కీ కోడి. ఓకే, ద టర్కీ ఎగ్ ఈస్ హ్యావింగ్ లైక్ దట్ ప్యాచెస్. దర్ ఇస్ టర్కీ ఎగ్ ఆల్సో ఎడిబుల్. దర్ ఇస్ ఎడిబుల్. ఐఎమ్ స్పీకింగ్ విత్ ఎడిబుల్. అంటే తింటారు, ఎడిబుల్ అంటే. అండ్ గూస్ ఎగ్. ఈ గూస్ ఏంటి సార్? ఎస్, గూస్ ఎగ్ కూడా ఉంటది, కాకపోతే ఏంటది, ఇది కాస్ట్లీ. ఓన్లీ 40 eggs in a year goose will give. That is a goose egg, which is like the duck egg. And సార్ కోయిల్ ఎగ్. ఇదేంటి సార్ కోయిల్ ఏంటి సార్? తెలుగులో ఏమంటారండి కోయిల్ ని? తెలుగులో ఏమంటారండి కోయిల్ ని? కోయిల కాదండి, కౌజు పిట్ట. కౌజు పిట్టను కోయిల్ అంటారు. దాన్ని ఇట్స్ వెరీ గుడ్ ఫర్ హెల్త్. దిస్ ఇస్ మోర్ గుడ్ దెన్ ద hen egg. And the pheasant egg, ఇదంటారు నెమిలి అంటారు, కానీ అది యాక్చువల్లీ ఇస్ నాట్ నెమిలి. అలాంటిది ఐ గాట్, బట్ ఐ సా ఇన్ ద తెలుగు డిక్షనరీ ఇట్ ద పీజన్ మీన్స్ నెమిలి ఆల్సో దే ఆర్ wrote over there. But it is like a duck egg. This also will be eaten. This pheasant egg. Ostrich egg. సార్ అది మేము సినిమాలో చూసినాం సార్, జేమ్స్ బాండ్ మూవీలో చూసినాం సార్. ఆస్ట్రిక్ వాళ్ళు తింటా ఉంటారు సార్ వేసుకొని. దట్ ఆస్ట్రిక్ egg is the bigger one, which is 20 chicken eggs is equal to one ostrich egg. Heaviest one in the bird. And the emu eggs, sir. Sorry, emu and sir, emu eggs. It is the like hen in the Australia. This will be there. And emu egg color is different. It is a bottle green color emu egg. Sir, ఇదే సార్ సీమకోడి. సార్ సీమకోడి కూడా తిన్నాం సార్, కానీ మేము మర్చిపోయినాం సార్. మేము ఓన్లీ బాతే చెప్పినాం, సీమకోడి చెప్పలేదు సార్ మేము. ఓకే, సీమకోడి కూడా తిన్నాం, కోడి గుడ్డు కూడా తిన్నాం సార్. ఎస్, సీమకోడి. ఇంకేంటి సార్? బంటమ్ ఎగ్స్. అరే ఈ బంటమ్ ఏంటి సార్? ఇది ఒక టైప్ ఆఫ్ ది కోడి. ఈ బంటమ్ ఎగ్స్ కూడా అది ఉంటది. ఇవి కంట్రీ ఎగ్స్ తిరిగానే ఉంటాయి. ఇంకేమున్నాయి సార్? అబ్బో క్యావియర్. ఇదేంటి సార్? చేప సార్. ఏ చేపగుడ్లు కూడా ఉంటాయి. ఓకే, చేపగుడ్లు కూడా ఉంటాయి. క్యావియర్. చేపగుడ్లని ఇంగ్లీష్ లో ఏమంటారండి? తొందరగా పాస్ అనండి, పాస్ అనండి, నేను చెప్తా. రో, ఆర్ఓఈ రో. ఇది చేపగుడ్లు. ఇవి చేపగుడ్లు ఇట్లుంటాయి. చేపగుడ్లు మామూలుగా చేపగుడ్లు హిల్సా ఎగ్స్ అంటే ఇవి ఇట్లుంటాయి చేపగుడ్లు. ఈ చేపగుడ్లు కూడా తిన్నాం సార్. ఎస్, చేపగుడ్లు కూడా తిన్నాం సార్. ఓకే, ఇది గుడ్ల గురించి. ఎందుకంటే గుడ్లు ఈజ్ ఏ పౌష్టిక ఆహారము. పౌష్టిక అంటే ఇందులో ప్రోటీన్స్ ఉంటాయి, విటమిన్స్ ఉంటాయి, ఫ్యాట్స్ ఉంటాయి. ప్లీజ్ ఐదర్ రా ఎగ్ ఆర్ బాయిల్డ్ ఎగ్ యూ ఈట్ డైలీ. వెన్ ఐ వాస్ డూయింగ్ ద ఎక్సర్సైజ్, ఎస్, when I was doing the exercise, I used to take the 2 raw eggs daily. Yes. Now come to our labor law. Yes. Do you want to ask anything? You can ask now. Yes. Or you can say proceed.
Proceed, sir.
Very good, very good, very good. If not, I told you already, my legs are fettered, my hands are handcuffed, my tongue is tied, unless until I hear the word. Yes, we are hearing you, sir, you can proceed. Labor law MCQ, there is the Trade Union Act 1926, where the labor law is the subject of the central list, state list, concurrent list, none of the above.
Central list.
State list.
ఇక మీ ఇష్టం వచ్చింది చెప్పుకోండి ఏమైతుంది ఇక యూజ్ ద లాజిక్ సెంట్రల్ యాక్ట్స్ కూడా ఉంటాయి స్టేట్ యాక్ట్స్ కూడా ఉంటాయి కాబట్టి ఏమైతుంది అది కాంకరెంట్ లిస్ట్ లో వస్తాయండి అల్లా ఓకే కమ్ టు ద పాయింట్ ద ట్రేడ్ యూనియన్ యాక్ట్ 1926 has chapter and dash chapter and dash sections. How many chapters and how many sections? Yes, how many chapters and how many sections?
5 and 33.
It is a 5 and 33 is the right answer. 5 and 33 means 5 chapters and 33 sections. Okay, the definition of trade union according to the Trade Union Act 1926 is not, NOT not, bold, same as the definition in the British Trade Union Act of 1871, 1874, 1875, 1939. Not another.
1870.
It is the answer is 1874 is the right answer for that one. Then the fourth question is which element or component? Which element, virgule or oblique or slash component is not a resulted in the growth of various trade unions in India? The conflict of interest between the workers and employers. 2. The distress of the workers. 3. In the issue relating the fairness of the pay, good working environment, hours of the work and other benefits. Then D is the negotiation, the domestic dispute between the marriage couples.
E, sir.
Last one, sir. Last one. D.
Yes, is not means they don't deal it this domestic couple negotiation with the domestic between the marriage couple, it will not come over there. Of course, it will deal about the maternity leave, it deal with the paternity leave, it deal about the health condition of the both the workers. Yes, come to the fifth one. The Trade Union Act 1926 does not deal the dispute conflict between
C, sir. Employers and landlords.
employers and landlords is the right answer for that one because the workman and employers definitely will deal workman to workman. Yes, it will deal and the employers and landlord it will not deal employers and the employees it will deal. Yes. Then the sixth one is a trade union can only be registered under dash. A Society Registration Act, Cooperation
Trade
Society
Union
Act.
Act
Trade Union
1926.
Act 1926.
Act 26.
The answer is Trade Union Act 1926. It will be registered under it. Then the next is the first clearly registered trade union is considered to be the founded by the BP Wadia in 1918. It is the first
All India
clearly
Trade Union
registered
Congress.
Madras Labor Union. That is the correct answer. BP Wadia. Madras Labor Union is the right answer for the question. Which union followed the which union followed the ideals of the truth and non-violence laid down by the Mahatma Gandhi? It was able to secure justice to the workers in a peaceful manner without harming the harmony in the society. The Printers Union of Calcutta, the Bombay Postal Union, Ahmedabad Textile Labourers Union,
Yes, sir.
and the All India Trade Union Congress. Ahmedabad Textile Labourers Union is the first where the Mahatma Gandhi, because Mahatma Gandhi hails from
Gujarat.
Ahmedabad.
అహ్మదాబాద్, గుజరాత్ ఈజ్ అ స్టేట్. అహ్మదాబాద్. బాబు ఎక్కడ ఉంటావురా బాబు? ఇండియాలో ఉంటాను బాబు. ఇండియాలో కాదు, ఎక్కడ ఉంటావురా బాబు అంటే అట్లీస్ట్ తాలూకా లెవెల్ అన్నా డిస్ట్రిక్ట్ లెవెల్ అన్నా అది ప్లేస్ లెవెల్ అన్నా చెప్పాలా. సార్ ఎక్కడ ఉంటావా? సపోజ్ యూ ఆర్ ఫారిన్ కంట్రీ, ఎక్కడ ఉంటావు బాబు నువ్వు? సార్ నేను కొత్తగూడెంలో ఉంటా సార్. వానికి ఏం తెలుసు కొత్తగూడెం ఏం తెలుసు, వానికి పాత కొత్తగూడెం ఏం తెలుసు. అప్పుడు వీ కెన్ సే ఇండియా. ఓకే, కమ్ టు ద నెక్స్ట్ పాయింట్ ఈజ్ విచ్ యూనియన్ ఫాలోడ్. Yes, which union followed the ideals of truth? Yes, this we did it because we already tell feedback I already given. Ahmedabad Textile Labourers Association in Gujarat, which is turned into the union under the guidance of Mahatma Gandhi. It is said. Next, the question is who is acclaimed as the father of the trade union movement in India? Who is the father of the trade union movement in India? Mahatma.
Lokhande, sir.
Answer is
Lokhande, Narayan.
Narayana Meghji Lokhande. N.M. Lokhande, he is the father of the trade union movement in India, not Wadia. Okay, now it comes to the point of the 10th. Who dash is the father of modern trade unionism in India? Modern trade unionism in India. Is it Mahatma Jyotirao Phule, King Bali, Sri N.M. Joshi, Nalini Pandit? Answer is Sri
Maybe N.M.
N.M. Joshi. Answer is Sri N.M. Joshi is the father of the modern trade unionism in India. Then the next question is the Constitution of India guarantees freedom of association as a fundamental right and confers the workers right to combine and organize for the collective action or bargain by virtue of which article? Collective bargaining.
91G, sir.
19(1)(c), sir.
Answer is 19(1)(c) that deals about the fundamental rights and confers the worker right to combine the organize the collective action. That is Article 19(1)(c). Yes. Now, which article in the right to property is removed?
F,
E, sir.
19(1)(f).
19 sub article 1 clause F. It is removed from the and which amendment?
43rd amendment. 43rd.
But it is in the Indira Gandhi period.
Huh?
It is in Indira Gandhi period.
No, it is during Janata's regime.
Janta Dal. Okay. Noted. Which trade union for the first time represented the Indian labor at the International Labour Organization? The first
It is
time.
All India Trade Union Congress.
It is the answer is All India Trade Union Congress is the first time represented in the Indian labor at the International Labour Organization. That is the right answer. The Indian Trade Union Act 1926 was amended in dash by which word Indian was omitted and the act was rechristened as the Trade Union Act. Otherwise, we will call the Indian Trade Union Act 1926, but Indian is removed over there from the which act in which year?
1946.
Answer is 1964. It is removed the India. Then only the Trade Union Act 1926 was made. Yes. Next question is Trade Union Act of 1926 is a welfare legislation, but not contains the provision for not contain. I say registration, regulation,
E, sir.
benefits or laws. Answer is laws.
Regulation.
Answer is laws because all the things are contained. Registration is contained, regulation is contained, and benefits are contained, but laws is not contained over there in the welfare legislation. That is the answer for that one is the laws. The 15th one, among the below given was not founder of any trade union. Among the below given was not I say not a founder of any trade union. Number one, Sri Soli. What is that? Sorabji, Shapatji, Bengali, Sri N.M. Lokhande. We already said, Lokhande is connected with Wadia already connected with, we already said. Then
E, sir.
Whitley.
Yeah.
Then either first one,
First one, sir.
either first one or the last one.
First one, sir.
No, it's the last one. It is the last one. It is the last one, Whitley. Whitley is not connected with the trade union movement.
Yes, it is an English name.
Not necessarily. Why? Yeah. But of course, I use the English name here because these people are Bengali, this Lokhande and Wadia also. They are belonging to the Indian movement with there. Then Whitley is the logic if we could use it. Suppose if I use another Indian, it will be difficult for you. But I did not use another Indian over there. That's why I used the Englishman so that at least we can use the logic and give the right answer for that one. Next question is the establishment of that has been principle of all the labor legislation in India.
Natural justice.
sir.
Natural justice.
Answer is social justice, not natural justice. It is a social justice. Is the establishment of social justice has been a principle of all the labor legislation in India. Then next comes the in India, following is not a type of agreement or prevalent for collective bargaining. I say not.
Unilateral.
Unilateral, sir.
Answer is unilateral agreement. Right answer. I appreciate. Yes. Because bipartite agreement is there, settlement is there, consent awards are there. Yes. And the next eighth one is settlements usually arise out of the conciliation process and they are usually tripartite in nature as they involve parties who are the parties?
All of the above. All of the above, sir.
Employer, employees, yes. Conciliation officer, yes. All the above will come. Is it? All the above are conciliation officer.
All the
All of
No, please read, see the question first. Settlements usually arise out of the conciliation process and they are usually
Yes,
repatriate in
sir.
nature as they involve parties which are,
Yes, sir. 3 because
They have to be 3, no, sir.
yeah, tripartite means 3, all of the above right answer. Yes, you are right, all of the above, because tripartite I already tell you. Then tripartite means employee, employer and a conciliation officer should also be there. Not a single conciliation officer can deal it unless సార్ అన్లెస్ ఎంపైర్ ఎప్పుడు కావాలండి? ఎంపైర్ ఎప్పుడు కావాలంటే ఇద్దరు కొట్లాడుకున్నప్పుడే కదా ఎంపైర్ కావాల్సింది. ఎంపైర్ ఎంపైర్ అంపైర్ యుఎంపిఐఆర్ ఎంపైర్. Yes, that is the word. That
umpire.
yes. The Trade Union Act 1926 is an important dash giving the provisions for the registration, regulation, benefits, protection of trade union. Is the economic legislation or a social legislation or liberal legislation or welfare legislation?
Welfare.
Legislation, sir.
It is a welfare legislation. That is the right answer for that question. Which is not the central trade union organization in India. I said not. Which is not the central trade union organization in India.
Janta Mazdoor, sir.
Janta Mazdoor Sangh.
It is the answer is there is no Janta Mazdoor Sangh, but other are organizations actually. Of course, I took a lot of time to make it
And
out.
Bharatiya Mazdoor Sangh.
Yes, there is a Bharatiya Mazdoor Sangh is there. That's why I took it a different way and we made the answer like that. Yeah, retired employees can form the union under Trade Union Act 1926. Madras Court decided in the case of. So Madras High Court decided.
D, sir.
Syndicate Bank.
Yes, answer is.
D, Karur Vysya Bank retirees versus.
It is a Karura Vaishya Bank Retired Association versus Deputy Commissioner of Labor.
Labor, yeah, D.
That is the D is the right answer. Karura Vaishya Bank Retired Association versus Deputy Commissioner of Labor, where the retired employees can also form the trade union under the Trade Union Act of 1926. Yes, penalties and procedures. I repeat, penalties and procedures comes under the Trade Union Act 1926 in which chapter it comes?
Chapter 5.
Chapter 5 is the answer. That is the penalties and procedure come under it. Next, any two or more registered trade unions may become amalgamated. See the question first. Understand. Any two or more registered trade union, any become amalgamated together as one Trade Union Act 1926 under Section 22, Section 23, Section 24, Section 25. Which one is correct? Amalgamated. I said amalgamated and become one. 22, 23, 24, 25. Answer is 24 is the right answer. Where it is amalgamated. Okay, now you tell me how many banks are amalgamated recently?
How many?
6, sir.
Okay, which is the latest one? Latest చెప్పాలి నాకు.
Andhra Bank, Canara Bank.
No, Punjab National Bank, I think.
No, first లేటెస్ట్ చెప్పండి. అంటే లాస్ట్ కి
Canara Bank ఎప్పుడు జరిగింది కదా సార్?
లాస్ట్ కి జరిగింది చెప్పాలి నాకు.
Oh,
Andhra Bank, Corporation Bank, sir.
Actually, Andhra Bank is the last bank where it is merged into the Union Bank of India.
Union Bank of India.
ఎస్ ఎందుకంటే నాకు మొన్ననే వచ్చింది ఆంధ్ర బ్యాంక్ నుండి అది మెసేజ్ వచ్చింది లేటెస్ట్ వన్ సార్ యువర్ అకౌంట్ ఈస్ సో నౌ యూనియన్ బ్యాంక్ ఈస్ దేర్ ఓహో దెన్ ఐ సెడ్ ఓ దిస్ ఇస్ ద లేటెస్ట్ వన్ the Union Bank of India it is made over there but I don't know because ATM card who will issue it I want to check it. Okay, come to the next point. 24th, which court or tribunal is having a jurisdiction to dispose cases under the Trade Union Act 1926? Yes,
Industrial Court Tribunal.
Industrial Court Tribunal is that. Oh, where is the appeal goes?
Huh?
Appeal.
Appeal.
Appeal goes to High Court, sir.
Appeal goes to next court, sir.
అసలు అవి సెంట్రల్ గవర్నమెంట్ కా స్టేట్ గవర్నమెంట్ కా ఇది
Huh?
స్టేట్ గవర్నమెంట్ కా సెంట్రల్ గవర్నమెంట్ కా
First it goes to High Court, then
High
to
Court and then Supreme Court, sir.
బట్ వెదర్ స్టేట్ ఆల్సో the state is also having a central tribunal and central also having the tribunal. Yes,
Oh, Central Tribunal అయితే Supreme Court వెళ్తుంది సార్ డైరెక్ట్ గా.
to my knowledge there is a state tribunal is there is a central tribunal is there.
sir,
Anyway,
ఏదైనా హైకోర్టు
anyway, it doesn't matter. ఏదైనా పర్వాలేదు. If it is the state, it goes to the High Court. If it is the appeal, it go to the Supreme Court because that is only the having the appellate authority. Okay, next comes under section TTUA 1926 punishable with fine which may extend it to 500. Yes. సార్ అసలు TTUA అంటే ఏంటి సార్ చెప్పండి. ఎస్ ద ట్రేడ్ యూనియన్ యాక్ట్ TT2A అంటే ద ట్రేడ్ యూనియన్ యాక్ట్ 1926. యాక్చువల్లీ TUA సరిపోతుంది, అనదర్ టీ ఈజ్ నాట్ నెసరీ దేర్. ఓకే, ద 1920 పనిషబుల్ విత్ ద ఫైన్ విచ్ మే ఎక్స్టెండ్ టు, అసలు ఫైన్ ఎంత ఉన్నది TUA ట్రేడ్ యూనియన్ యాక్ట్ 1926 ఎక్స్టెండెడ్ టు 500 ఉన్నది. విచ్ సెక్షన్ ఇట్ డీల్స్ అబౌట్? సెక్షన్ 31 sub article 1, sorry, subsection 1, 31(2), 31, 33(1), or 33(2). Answer is 31(2). Means section 31 subsection 2. It is the right answer, not 33(2). How many total labor legislation in India? అందరికి తెలుసు ఇప్పుడు ఇది. అది ఈజీ క్వశ్చన్. ఎందుకంటే నాలుగు అయిపోయినాయి.
అపార్ట్ ఫ్రమ్ 45 కాకుండా ఇంకొక 200 స్టేట్ లెజిస్లేషన్స్ కూడా ఉన్నాయి సార్.
No, I'm speaking about the central legislation.
45 సార్.
44 ఉండే ఇప్పుడు. now the 44 are becoming 4 now. Only 4 legislation. No, check it. It is 44 is turning to that 4 now. Anyway, check it because that 4 is definitely either 45 doesn't matter, 44 doesn't matter, but 4 is going to come. And all other legislation will be no more now. Okay, as of course going to be made sooner or later. Yes, certain acts not applied to the registered trade union dash. The following acts namely not apply to registered trade union, like the Society Registration Act, the Cooperative Society Act, the Company Act, all of the above. Yes.
The Company Act 1956.
Yes, all of the above. All of the above. Certain acts not apply. Not apply to registered trade union. Means Society Registration Act will not. All Cooperative Society Acts also not. Company Act also not. And it's all of the above is the answer for that one. Okay, next case law. Supreme Court allowing registered trade union to initiate the resolvency proceedings as operational creditors on behalf of their members, and the insolvency and the bankruptcy code 2016 decided in the case of, I repeat, Supreme Court allowing the registered trade unions to initiate insolvency proceedings as operational creditors on behalf of their members under the insolvency and the bankruptcy code 2016 decided in the case of. ఏ కేసులో చేశారు? Because there is jute mills mazdoor morcha verse Jugilal Kampal Mat Cotton Mills Company Limited. So I changed here and there. The right answer among them is K Jute Mill Mazdoor Morcha versus Jugilal Kamlapat Jute Mills Company Limited is the right answer. Where bankruptcy code insolvency proceedings can also be initiated. So that was the thing. Okay, now K Jute Mills Mazdoor Morcha case law, Supreme Court has adopted a dash interpretation in an attempt to support workmen in recovering their dues from bankrupt companies. A rule applicable chesindi. Rule, golden rule, virtuous rule, purposive rule.
Sir, purposive rule.
This is the purposive rule. The purposive rule, in what purpose it would be there, though the purpose should be served over there, hence the purposive rule can be adopted when they are giving the judgment in favor of the party. Next, employees of the ESI. Sir, ESI ante cheppandi sir.
Employee State Insurance.
The employees of the State Insurance Corporation would come within the meaning of workman, and hence they could be registered under the Trade Union Act was decided in the case of a case law decided అయింది. అసలు నాకు అడుగుతా ఎంప్లాయీ స్టేట్ ఇన్సూరెన్స్ ఎవరికి వర్తిస్తుంది? ఓకే, నౌ ఇట్ టెల్.
Sir, Tamil Nadu NGOs Union versus the register of trade unions.
It is the Register of Trade Union versus West Bengal versus Mihir Kumar Gocho. That is the case law where it is decided. But what is the ESI applicable to whom? Who will get the benefit?
Em- State government employees.
Are you sure it's the state government employees? ESI,
Yes, sir.
central government employees, not state government employees.
Sorry.
ESI applicable only to the central government employees. Plus, where the 20 or more than 20 will be there, at the time, ESI should be there for them. ESI applicable like that. And for state government, there is a certain scheme is there, central government. I don't know. Of course, PF, GPF, both are different. Oh, no, sorry. PF is applicable to the more than 20 would be there. For GPF applicable to the government employees and the central employees, ESI is applicable. So anyway, subject to it, you check it. ESI is applicable to whom? You check it. Anyway, come to the point. The term collective bargaining was used by Dash in 1897 for the first time in his famous book, Industrial Democracy. He emphasis on the correct spelling of author. Beatrice Webb, Beatrice Webb, Beatrice Webb, Beatrice Webb, who is the person who wrote the collective bargaining in 1987 for the first time in his famous book, that is Industrial Democracy. That was a book written by, concentrate on the spelling, I said, emphasis on the correct spelling. Which is the correct spelling? Beatrice Y, Beatrice Webb, or Beatrice Webb, or the D last one. Answer is, the last one is the right answer. That is Beat Rice Webb. V-E-B-B. That is the person who wrote the Industrial Democracy book. Okay, come to which is not right of a registered trade union under the Trade Union Act. Registered trade union, I said. Which is not of the registered trade union under the Trade Union Act 1920. Right to own
To
property,
own property, sir.
right to sue, right to inspect
Right to
books.
inspect houses.
Right
Yes.
to ins-
Right to inspect houses.
Right to inspect houses is not the registered trade union activity. Right to own property, yes. Right to sue, yes. Right to inspect books, yes. So that was the right answer to know the thing. Now at least half of the time is over. Now 3:29. So we do have something. Then we'll go in the reverse order so that we can complete this one. The reverse order will go dash section. Section dash lay down the procedure for retrenchment under the Industrial Dispute Act 1947. Yes. Retrenchment. తెలుసు కదా retrenchment అంటే removing the employees because of the employer some unavoidable circumstances, or the employees are more,
some loss.
or because of pandemic also. Yes, which section says? I say retrenchment. 25G.
25F.
25G, capital G, 25G is the right answer for that, where the retrenchment will come. Next is Supreme Court of India held imposing and continuing the lockout. I'm speaking about the lockout here. Deemed to be illegal under the ID Act is an unfair labor practice observed in the case of. A case law observed it is a illegal. Lockout is illegal. Imposing and continuing a lockout deemed to be illegal under the ID Act, unfair labor practice observed in the which case law?
Mazdoor labor.
Answer is because I gave the General Labor Union, then Mazdoor Labor Union, then Bharat Labor Union, then Indian Labor Union. But BV Chavan is a common. Answer is General Labor Union versus BV Chavan and others case law. It is made illegal. That is the answer for the question. Next comes the central government has laid down the foundation of the dash which would repeal the ID Act. Is the Information Technology Code, the Industrial Relation Code, the Company Relation Code, the Industrial Relation Act.
Code, sir. Code.
The Industrial Relation Code. Answer is the Industrial Relation Code is removed. The central government has laid the foundation of the Industrial Relation Code, which would repeal the ID Act.
Yes, sir.
Yeah, that
Instead
is.
of, it has formulated code.
Yes. So now again we say what are the extent loss means. Extent, EXTANT, not EXTENT.
Laws which are not applicable
EXTANT.
now.
What are the extent loss means here? A, extension loss. B, stretch loss. C, survived. D, none of the above.
None of the above ఉండాలి సార్. ఎందుకంటే extent laws అంటే which are not applicable now.
Survived or living loss?
Survived
Survived.
అంటే they are still applicable and sir. Extent laws
Yes.
అంటే they are not applicable anymore.
But anyway, that answer I found it. It is survived or living loss that made. But anyway, check it. You check once again this answer. What are the extant loss means? Okay, subject to this verification. Now come the. It is often noticed that industrial tribunal or a labor courts don't hesitate to take an employee dash dash legal view, moral view, friendly view, customary view. I said don't.
Legal view,
I said
legal
don't.
view.
No, they take the legal view. They take the
Not
moral view
hesitate to
also.
take.
They
అంటే
take the
తీసుకుంటారు
customary view
ఏమంటారు
also.
సార్?
Only friendly view they could not take it. Say I said not. So only friendly view could not be
Hesitate to
taken.
take అంటే తీసుకుంటారు అని సార్.
Do not see the point is it is often noticed that the industrial tribunal or labor court do not hesitate to take an employee means తీసుకుంటారు, లీగల్ వ్యూ తీసుకుంటారు, moral వ్యూ తీసుకుంటారు, కస్టమరీ వ్యూ తీసుకుంటారు, ఫ్రెండ్లీ వ్యూ
మోరల్ వ్యూ
తీసుకోరు.
తీసుకోరు సార్. మోరల్ వ్యూ తీసుకోరు, ఫ్రెండ్లీ వ్యూ తీసుకోరు, కస్టమరీ వ్యూ తీసుకోరు సార్. దే డు
Yes,
నాట్
this-
హెసిటేట్ టు టేక్ ద లీగల్ వ్యూ. లీగల్ వ్యూ తీసుకోవడానికి మొహమాట పడరు. బట్ మోరల్ వ్యూ తీసుకోవడానికి హెసిటేట్ చేస్తారు, ఫ్రెండ్లీ వ్యూ తీసుకోవడానికి హెసిటేట్ చేస్తారు, కస్టమరీ వ్యూ తీసుకోవడానికి హెసిటేట్ చేస్తారు.
Mhm.
హెసిటేట్ చెయ్యండి అంటే లీగల్ వ్యూ తీసుకోవడానికి హెసిటేట్ చేయరు, బికాస్ లీగల్ వ్యూ తీసుకోవాలి కాబట్టి.
Yeah, sometimes they will see the moral view also, no?
నో సార్, మొరాలిటీ డిఫర్స్ ఫ్రమ్ పర్సన్ టు పర్సన్ అండ్ లీగాలిటీకి వచ్చేసరికి మొరాలిటీ అనేది డెఫినెట్ గా పనిచేయదు సార్
Okay, okay.
లీగల్ సిస్టమ్ లో, బికాస్ ఈచ్ పర్సన్స్ మొరల్ పాయింట్ ఆఫ్ వ్యూ ఇస్ డిఫరెంట్.
Yeah, okay, we'll consider it. Yes, what you said, there is a logic. There is a logic it. Please check it again. There is a logic in there. Okay, I do admit it. Yes, next, just mute it because I'm getting the resound. When you are want to speak at the time, you can speak. Yeah, come to the point. Next is here salient features of the Industrial Dispute Act 1947 bear a huge impact on the settlement and prevention of the industrial dispute, as well as in dash of the condition of worker. Use the appropriate legal and suitable terminology in the two places. That is enhancement, improvement, amelioration, or betteration. Answer is it is amelioration is the right answer for the place where it should be used. That is as well as in amelioration of the condition of the workers, they will check it. The amelioration is the right word. Of course, this is a lengthy one. It is a difficult. We can go to the another one, easy one, which is easy to make it out. The settlement of industrial dispute under the ID Act 1947. One is not the machinery to decide adjudication dispute. I say not the machinery. Labor court, district tribunal, industrial tribunal, national tribunal.
లేబర్
Yes.
కోర్ట్ సార్.
Pardon?
లేబర్ కోర్ట్ సార్.
No, every district is having the labor court and labor court.
ఇండస్ట్రియల్ డిస్ప్యూట్స్ కాదు సార్ ఇది. లేబర్ కోర్ట్స్ ఆర్ బిట్వీన్ లేబర్ అండ్ అదర్ ఎంప్లాయీస్ ఆర్ ద మేనేజ్మెంట్.
No, it will deal. Labor court will deal.
సో
The
టూ
district-
ఇండస్ట్రియల్
డిస్ట్రిక్ట్ ఇండస్ట్రియల్ ట్రైబ్యునల్ ఉంటది, నేషనల్ ట్రైబ్యునల్ ఉంటది, లేబర్ కోర్ట్ ఉంటది, ఒకటి డిస్ట్రిక్ట్ ట్రైబ్యునల్ ఉండదు. లేబర్ ట్రైబ్యునల్ ఉంటది కానీ డిస్ట్రిక్ట్ ట్రైబ్యునల్ ఉండదు. సో నాట్ అన్నప్పుడు డిస్ట్రిక్ట్ ట్రైబ్యునల్ విల్ నాట్, లేబర్ కోర్ట్ విల్ డీల్ ఇట్, ఇండస్ట్రియల్ ట్రిబ్యునల్ విల్ డీల్, నేషనల్ ట్రిబ్యునల్ విల్ డీల్, ఆర్ సెంట్రల్ ట్రిబ్యునల్ ఆల్సో డీల్. దెర్ ఇస్ నో డిస్ట్రిక్ట్ ట్రిబ్యునల్. డిస్ట్రిక్ట్ ట్రిబ్యునల్ అనేది లేదు, నామినిక్లేచర్ లేదు. So now come to there are many major disputes under the Industrial Dispute Act. Among the following is one is not related to ID Act. Not related to ID Act. Political interference, unfair labor practice, economic speed up. Answer is economic speed up. It is not there. Okay. Now
One
we'll
and
see.
one.
Yes, lockout is the dash of the strike.
Antithesis.
Synonym of strike.
Antithesis of strike.
Synonym, antithesis, second step, none of the above.
Synonym, sir. Synonym.
No.
Antithesis of strike.
Antithesis. Lockout is the antithesis of strike.
Lockout is actually opposite of strike. When the management decides to close the company or industry,
You are right. Then they will make a lockout.
Okay.
They will make the lockout. అరే మీరు తీయడం ఏంద్రా నేనే బంద్ చేస్తారా అంటాడు. మీరు స్ట్రైక్ చేయడం ఏంద్రా నేనే బంద్ చేస్తారా అంటాడు. ఇప్పుడు కోతి ఉన్నదనుకోండి చెట్టు మీద, ఇప్పుడు మనకు మామిడికాయలు కావాలనుకోండి, ఏం చేయాలి, మనం ఒక రౌత్ వేయాలా, కోతి ఏం చేస్తుంది, మామిడికాయతో కొడుతుంది. ఓకే. Now comes the ID Act prohibits unfair labor practice which are defined in the dash. In which? First schedule, second schedule, third schedule, fifth schedule. Labor practice. Answer is, it is the fifth schedule, it is defines what is the unfair labor practice is divided in the fifth schedule. Okay. Next, the ongoing globalization in India requires drastic changes under which of the labor legislation? Factories Act, Employees State Insurance Act, the Employees Provident Fund Act, or none of the above?
Factories Act, sir. Oh,
None of the above.
Industrial Dispute Act.
No, none of the above. Here, none of the above is the answer.
Correct answer.
Yes, actually, the Industrial Dispute Act is the correct answer for that one. Okay, come to the next. Which of the following is an illegal industrial action as per the IDA Act 1947? I say illegal action.
Lathi charge. Oh,
Hmm.
Gerav.
Gerav is the right answer. Okay. Grievance handling machinery is mentioned in. Grievance handling machinery is mentioned in Factories Act, Industrial Dispute Act, Workmen Compensation Act, Federal Accident Act.
B, sir. Industrial Disputes Act.
Automatically, it is the Industrial Dispute Act. It will come over there. Yes, which of the following institution are authority for settlement of industrial dispute? Yes,
Industrial Tribunal.
Indian Labour Commissioner, Joint Management Council, Industrial. Answer is Industrial Tribunal is the answer for that one. There is a Industrial Tribunal is there, but there is no district tribunal. There is a labor court is there. So that is what I want to say is there. Yeah. Now next, the principle of first come and last go first go is applied in.
Retrenchment. C.
Answer is retrenchment. The C is the right answer for that one. But generally first come first served, is it not? Okay, come to the next point. Which one of the following is not a machinery officer for settlement of industrial dispute under the Industrial Dispute Act of 1947? A. Conciliation officer. B. Board of Conciliation. C. Collective bargaining. D. Labor court.
D. Labor court.
Collective bargaining. I repeat, which of the following is not machinery or officer for settlement of the industrial dispute under the Industrial Dispute Act 1947? Because conciliation officer is there, yes. Board of Conciliation is there. Only collective bargaining, it is not there. But labor court is there, yes. Collective bargaining is not there. That is only the question. Next, which point is an unfair labor practice on the part of the workman? I repeat, which point is an unfair labor practice on the part of the workman? Number A.
To indulge in acts of force and violence.
Answer is
Violence.
indulging in a coercive activity against the certification of a bargaining representative is the right answer, not the D. It is the
Sir,
B.
all of the above. C. Recruiting workmen during a strike, illegal adi. Indulging in coercive activities, illegal. Discharge or dismiss workman, adi subject to discussion. To indulge in acts of force and violence, adi illegal. All are, which is not illegal, Nara. Okay. Okay, C. C, sir. Discharge or dismiss of workman.
Okay, now we see that recovery of money is due from an employer by virtue of which Section Industrial Dispute Act will work. I say recovery of money is due from an employer by virtue of which section of Industrial Dispute Act? 33, 33A, capital A, 33B, or 33C? Answer is 33C. Capital C is the right answer, where the recovery of money is made from an employer by virtue of section 33C.
Recovery is it from
Yeah,
employer?
yeah, due from an employer. Yeah, they can recover that from the employer. Yeah, yes, no, no. Now you will see a workman who is a member of the executive or officer, other officer, bearer of a registered trade union connected with the establishment is dash conciliation officer, badly workman, protected workman, a skilled labor. Answer is protected workman. Protected workman. He will come under the protected workman. Next is okay, this will make it out easy. The proceedings before an industrial tribunal are dash in nature with all the attributes of a court of justice.
Quasi judicial, sir.
Quasi judicial, sir.
Executive, administrative, judicial, it is the quasi judicial in nature. Like,
Tribunal.
yeah, tribunal means generally is a quasi judicial in nature. Number one. Number two, if you take the even Consumer Protection Act also, where the consumer courts are quasi judicial in nature. Even that thing also.
Any tribunals are quasi judicial, sir.
Mostly,
Environment
mostly.
తీసుకోండి,
All. We can say all are. Yes, quasi judicial in
Yes, sir.
nature. Yes. Including the what is the collector? Collector.
Quasi judicial, sir.
It is a quasi judicial because for the Food Adulteration Act or Essential Commodities Act, and for that the collector also yes, that also quasi judicial nature, because that's why we say collector is a executive officer or a judicial officer.
All executive sides officers, quasi officers.
The collector is said to be the executive officer. Is. Now come to the next point is which section deals with the compensation to workman in case of a transfer of undertaking. See, compensation to a workman in case of transfer of undertaking, section 25, section 25F, section 25FF, and section 25E. Sir, first we did not answer. Which section deals with the compensation to workman in case of transfer of undertaking? Section 25FF. That is the answer for the question. Okay, how much compensation does the workman deserve at the time of retrenchment? How much compensation does the workman deserve at the time of retrenchment? Equivalent to
30
15
days
days,
average pay, sir.
6 months, equivalent to 30 days an average pay, or none of the above?
C, sir. Equivalent to 30 days average.
Answer is equivalent to 15 days average pay. It is the answer which is given over there. Okay, next. A workman who is employed in an industrial establishment in the place of another workman whose name is borne on the muster rolls of the established is called temporary workman, permanent workman, badly workman, ad hoc workman.
Badli.
It's
Badly
called
workman.
badly workman. Suppose మా ఫాదర్ కి జ్వరం వచ్చింది సార్, ఇవాళ నేను చేస్తా పని అని చెప్పింది అనుకో, అది బదిలీ వర్కర్ కింద వస్తుంది. Because yeah, that is the arrangement over there. Okay, how many days of service will be termed as a continuous service when working in a mine industry?
365 days.
190 days, sir.
Oh, mining ki there is a general.
Mining. I'm speaking mining. It is a 190 days. ఇప్పుడు ఎవరైనా సరే మైనింగ్ లో తీసుకున్నారు అనుకో, ఒక్కరోజు బ్రేక్ ఇస్తారు వాళ్ళు, లేకుంటే కంటిన్యూస్ చేయాల్సి వస్తుంది. ఒక్కరోజు బ్రేక్ ఇచ్చి ఏం చేస్తారు, మళ్ళీ కంటిన్యూ చేస్తారు. ఏది బదిలీ వర్కర్స్ కూడా, ది క్యాజువల్ వర్కర్స్ ఉంటారు కదా. సో దట్ వే దే కెన్ మేక్ ఇట్ అవుట్. Of course, now contract workers are there.
Is it 180 days or 190 days?
190 days. It is 190 days. So now they are given to the contract workers. So there is no question of permanency would be there. Like contract, I don't know what is the contract lecturer fate, because I saw in the WhatsApp where the many times ఇప్పుడు మన తెలంగాణ రాష్ట్రంలో ఒక్కరు కూడా కాంట్రాక్ట్ మీద పనిచేయరు, అందరిని పర్మనెంట్ చేసేస్తాం. బికాస్ దట్ ఈస్ మేడ్ ఇట్ ద థింగ్, బట్ ఓన్లీ ఐ డోంట్ నో హౌ ఫార్ ఇట్ విల్ బి.
Diluted words.
No. See, we should not promise it. When you promise, try to keep it at the cost of your death also. So that's the generally it's my principle. Okay, come to the point. Section dash covers the definition of the continuous service. Which section deals about the continuous service? 25, 25A, 25B, 26. Continuous service. It is a section 25 capital B, which deals about the continuous service. Yes, within 4 minutes it is going to be closed. Okay, up to that action we will run the show. Yes, the arbitration award shall remain in operation for a period of dash year as mentioned in the act. Arbitration award shall remain in operation for a period of 24 months, 6 months, 1 year, none of the above. Award, arbitration award, ఎంతవరకు వ్యాలిడిటీ ఉంటుంది దానికి? It is 1 year. Award is validity up to 1 year. And another award should be published also. There is another point. Yes, come to the next point is, which section deals with the payment of wages to workman pending proceeding in higher court in the act? Section చెప్పండి. ఇండస్ట్రియల్ ట్రిబ్యునల్ యాక్ట్ లో, ఐడి యాక్ట్ లో ఏ సెక్షన్ డీల్ అవుతుంది? పేమెంట్ ఆఫ్ వేజెస్ టు వర్క్మెన్ పెండింగ్ ప్రొసీడింగ్స్ లో ఉన్నప్పుడు, ఏది హైకోర్టులో పెండింగ్ ఉన్నప్పుడు. ఎస్, it is 17 capital B. When the case is pending over there in the High Court, at that instance, you have to pay some wages. Otherwise, how he can survive? Okay, next. What is the time period in which all the awards of the arbitration are to be published from the date of its receipt by the appropriate government? 1 day, 7 days, 15 days, 30 days.
30 days.
30 days award that you should be published over there in the local newspaper, that will be the language which is known to the public. How many days of notice has to be given to the workman by the employer in case of any changes to be made in the service condition specified in the fourth schedule? 30 days, 15 days, 21 days, 45 days. 25 days is the right answer. Sorry, 21 days is the right answer for that one. 21 days of notice has to be given to the workman by the employer in case of any changes to be made in the service conditions specified in the fourth schedule. It is clearly mentioned. Next comes, what is the required minimum age for a person to be appointed in the office of the presiding officer of a labor court or tribunal or national tribunal? What is the minimum age? I
60
say, what
years.
is the minimum age? Why say the minimum age?
60 years.
Yeah, appointed the office presiding officer labor court or tribunal or national tribunal. Of course, వీళ్ళందరినీ ఏంటంటే రిటైర్ వల్లనే పెడతారు కాబట్టి ఆన్సర్ ఈజ్
58 అనుకుంటా సార్.
it is 65 years అంటాను.
మినిమం 65.
యా, ఎందుకంటే జనరల్లీ రిటైర్డ్ వాళ్ళనే పెడతారు ఇక్కడ.
ఎస్ సార్, మనం ట్రిబ్యునల్స్ లో చూసుకుంటే మాక్సిమం ఏజ్ మనకి 65 వస్తుంది సార్.
ఇప్పుడు మనం హైకోర్టు చూసుకుంటే ఎంత వస్తుంది? 62. హైకోర్టులో చూసుకుంటే 62 వస్తుంది, సుప్రీంకోర్టులో చూసుకుంటే 65 వస్తుంది. సో ఎనీవే, బట్ ఐ డోంట్ నో, ప్లీజ్ చెక్ ఇట్ వన్స్ అగైన్. ట్రిబ్యునల్ కానీ, లేబర్ ట్రిబ్యునల్ కానీ, నేషనల్ ట్రిబ్యునల్ కానీ మినిమం ఎంత ఉండాలా వాళ్ళకు? ఎందుకంటే జనరల్లీ రిటైర్డ్ జడ్జెస్ ఆర్ మేడ్ ఫర్ ద దీస్ ట్రిబ్యునల్స్. మ్యాక్సిమం రిటైర్డ్ జడ్జెస్ వస్తారు ఇక్కడికి. అచ్చా, ఎనీవే, విల్ కమ్ టు ద విచ్ సెక్షన్ ఈస్ ద ఇండస్ట్రియల్ డిస్ప్యూట్ ఆర్ డిస్కస్ అబౌట్ ద డిస్క్వాలిఫికేషన్ ఆఫ్ ద ప్రిసైడింగ్ ఆఫీసర్ ఆఫ్ లేబర్ కోర్ట్. డిస్క్వాలిఫికేషన్ ఎవరికి ఉంటుంది? ఏ సెక్షన్ ఇచ్చిండు? ఆన్సర్ ఈజ్ 7C, where the disqualifications are given for the presiding officer of the labor court. Okay, how many persons shall a national tribunal consisting of which is to be appointed by the central government?
3.
How many persons shall a national tribunal consist of is to be appointed? అసలు అపాయింటెడ్ సెంట్రల్ గవర్నమెంట్ అపాయింట్ చేసేది ఎంతమంది? ఒక్కడే చేస్తారు సెంట్రల్ గవర్నమెంట్.
It is odd.
Yes. No, central government I am speaking about, central government.